Welcome to This Explainer. Today, we're unpacking a truly fascinating puzzle from the South African Constitutional Court. Imagine for a second fighting a grueling legal battle all the way up to the highest court in the land. And you win. You actually win. You secure this massive victory for constitutional rights. Naturally, you'd expect the losing side to pick up your incredibly heavy legal tab, right? Well, not so fast. In the landmark case of Ferreira versus Levin NO, the applicants discovered a really harsh reality. Sometimes winning a major constitutional case still leaves you holding a massive legal bill. So why does this happen? That's exactly what we're going to uncover today as we explore why constitutional costs remain so incredibly complex.
Okay, let's dive into this. Here's our roadmap for today. 1. A hollow victory. 2. The rules of legal costs. 3. Defining substantial success. 4. Exclusive jurisdiction. 5. The chilling effect. And 6. The final verdict.
Section 1. A hollow constitutional victory, the landmark ruling that didn't pay out.
So the applicants in this case, Ferreira and Vryenhoek, were facing a really tense legal inquiry under the Companies Act. They strongly objected to answering questions that might incriminate them. They argued that Section 417(2)(b) of the Act literally forced them to give evidence that could later be used against them in criminal proceedings. Unwilling to back down, they took this all the way to the Constitutional Court, fighting tooth and nail to protect their fundamental right against self-incrimination. And against all odds, on December 6, 1995, the court officially declared Section 417(2)(b) invalid. I mean, this was a massive headline-grabbing win for constitutional rights. Naturally, having scored this historic victory, the applicants fully expected the respondents, the liquidators, and the master of the Supreme Court to cover their hefty legal costs. In almost every area of life, if you win the contest, you get the prize, right?
But, well, here comes the twist. Listen to this precise wording from Justice Ackerman. In all these circumstances, it appears just and equitable not to award the applicants their costs. Wait, what? No way. They won a landmark constitutional ruling, but the judge firmly denied them their legal fees. It's a total paradox. To understand how a judge could look at a victorious party and say, yeah, you still have to pay your own way, we really have to look closely at the underlying machinery of how legal costs actually work. Section 2. The rules of legal costs, setting the Supreme Court baseline. Before we can fully grasp the constitutional curveball Justice Ackerman threw at the applicants, we've got to understand the fundamental baseline rules of how costs are traditionally awarded. Normally, the general rule applies. The successful party gets their costs. And this is the very rule the applicants were heavily relying on. But sitting right in tension with that is the overriding rule. The award of costs is entirely at the discretion of the presiding judge. While winning usually means getting paid, judicial discretion allows for a whole host of exceptions. A judge can completely deprive a successful party of their costs based on how they conducted themselves, if their success was just a minor technicality, or based on the unique nature of the proceedings. The rules are incredibly flexible and adaptable, which is exactly why constitutional costs remain complex. Winning the headline absolutely doesn't mean you automatically win the invoice. Section 3. Defining substantial success. Did the applicants really win the war? Now, we have to peel back the layers of this supposed victory. The applicants claimed they had no choice but to go to court, and that they definitively won their case. But we have to look critically and ask, did they actually achieve substantial success against these specific respondents? This perfectly illustrates what I like to call the illusion of victory. Think about what the respondents actually wanted. They were simply liquidators conducting a routine inquiry. They just wanted answers to their questions about a company. The applicants, on the other hand, wanted silence to avoid self-incrimination. So what was the ultimate ruling? The court said the applicants still had to answer all the questions put to them by the respondents. The only catch was that the state could no longer use those answers in a future criminal trial. So, in the context of the actual room, the applicants still had to sit down and give the respondents exactly what they wanted: the answers. The logic here is actually super fascinating. You see, the respondents had absolutely no control over future criminal proceedings by the Attorney General anyway. They were private parties running an inquiry. They had neither the interest nor the power to consent to evidence not being used criminally. Therefore, the applicants' grand constitutional victory over the Companies Act didn't actually affect the core substantive dispute between the two parties. Sure, the applicants won a powerful shield against the state, but they did not win the substantive dispute against the respondents sitting right across the table from them. Section 4. The exclusive jurisdiction factor, why opposition didn't matter.
Here we're going to introduce the structural mechanics of the Constitutional Court itself, which added another massive layer of complexity to the applicant's demand for legal fees. Under Section 98(2)(c) of the Constitution, striking down an act of Parliament falls under the exclusive jurisdiction of the Constitutional Court. Now, why is this critical for our costs puzzle? Well, imagine if the respondents had just thrown their hands up on day one and said, you know what, applicants, you're right. That section of the act is completely unconstitutional. We totally agree. It wouldn't have mattered because a formal act of Parliament was being challenged. All the parties still would have had to travel up to the Constitutional Court. The court still would have required full oral arguments, admitted outside expert opinions, solicited deep memorandums, the whole shebang. The respondents' opposition didn't actually increase the core costs of striking down the law. Furthermore, the procedures that got them there were, frankly, incredibly messy. The case arrived at the Constitutional Court through a referral process that was deeply flawed. For a valid referral, 3 strict conditions must be met. It must be a decisive issue, within exclusive jurisdiction, and in the interests of justice to refer. Justice Ackerman pointed out that absolutely none of the issues in this case were referred correctly. He sharply warned that parties shouldn't just supinely consent to bad referrals. They should fight bad procedures early on instead of just sitting back. Because both sides messed up the procedural mechanics, it severely impacted how the judge viewed the final cost award. Section 5. The chilling effect, zooming out to the macro policy level. Let's step away for a second from the specific facts of Ferreira and Levin to examine the wider implications of constitutional legal costs on everyday citizens like you and me. This brings us to a really crucial legal concept, the chilling effect. This is the risk that private individuals will be deterred from asserting their constitutional rights against the state due to the fear of devastating adverse legal cost orders if they lose. Imagine knowing your absolute rights are being violated, but you're too terrified of bankruptcy to sue the government. Protecting citizens from this chilling effect is a profoundly important policy issue in constitutional law. Courts desperately want to encourage people to defend the Constitution without the looming terror of financial ruin. But context is everything, right? When an individual sues the state, the chilling effect is a massive concern. But this case? This was private versus private litigation. Justice Ackerman explicitly clarified that while the chilling effect is a vital policy issue, it doesn't automatically dictate how costs should be handled when 2 private entities are fighting each other. In this specific case, it was private applicants fighting private liquidators. Because the powerful state wasn't the opponent, the chilling effect argument didn't just give the applicants a free pass on their legal bills.
Section 6. The final cost verdict, solving the puzzle.
So, we've seen the hollow victory, the incredibly messy court procedures, and the limits of the chilling effect. Now let's look at how the court finally resolved this complex procedural journey. Here is the definitive answer, straight from the judgment. Justice and fairness in the present case would, in my view, best be served if all parties were ordered to pay their own costs. That is the final verdict. Because the applicant's success against the respondents was largely an illusion, because the strict jurisdictional rules necessitated the Supreme Court visit regardless of any opposition, and because both sides stumbled through the referral process, the absolute fairest outcome was simply for everyone to swallow their pride and pay their own bill.
So the crucial point for us to take away is this. Constitutional litigation rules must be flexible, adaptable, and decided on a case-by-case basis. You can't just apply a rigid algorithm. The reason why constitutional costs remain complex is because true justice requires a judge to look far beyond who simply won the headline. They have to deeply examine the substantive dispute, the procedural mechanics, and the broader macro policy implications to ensure the cost order is genuinely fair to everyone involved. I'm going to leave you with this provocative thought to ponder. Does the threat of massive legal fees ultimately protect the courts from frivolous claims, or does it silently price out the average citizen from seeking true constitutional justice? It's an incredibly delicate balancing act, and cases like Ferreira versus Levin show just how intricate that balance can be in reality. Thank you so much for joining me on this explainer, and definitely keep questioning the structures that govern our world.